Thomas FARINELLA did challenge jury instructions, and upon the request of the judge, Judge DONNELLY, he did submit his findings with Boyle versus the United States to Judge DONNELLY for the afternoon session to review it. In the afternoon session, after Thomas FARINELLA, defense counsel for Robert Kelly, submitted his review, Judge DONNELLY stated, "I did review Boyle versus the United States, which is a case that Mr. FARINELLA submitted. That doesn't stand for the proposition that every member of the enterprise has to participate or know about its activities. But one thing I will say about the government's proposed charge, which is on a really entirely separate matter, is that I think the first two sentences, moreover, it is not necessary to prove that every member of the enterprise participated in or knew about all the activities. Rather, it is sufficient that the defendant know the general nature of the enterprise and know that the enterprise extends beyond his individual role." The next two sentences are, the next two sentences are really not appropriate for the case like this. It may be appropriate in some other case, but the language that is not necessary to prove that the enterprise or its members acted with criminal intent is, I don't think it's appropriate for this case, so I'm not going to give that. Then the government challenged it. Ms. Geddes said, "Your Honor, with respect to Your Honor's ruling about those second two sentences," the judge responded, "I thought I could go through that so quickly that you would forget about it." Ms. Geddes, not so. "We anticipate that the defense is going to argue that there was nothing illegal about the enterprise, and we're not saying that there was something illegal about the enterprise, and so that is why we wanted that additional language to make clear that the jury, only needs to find that the defendant acted with criminal intent and not that anyone else acted with criminal intent, because I think that's going to be the significant focus of defense closing." Judge DONNELLY responded to the government, "Well, I think that's an accurate statement of the law, but I don't think the sentence that the enterprise, I think the rest of the charges adequately convey that, but that one sentence I don't think does. Obviously, the defendant has to act with the requisite intent. I don't think anybody would quarrel with that. I think I say that in other places in the charge, but I will add that sentence again. I'm just not going to put under the circumstances of this case. I think it would be confusing to say that the enterprise doesn't, when the person who is the head of the enterprise is the defendant under the government's theory. So maybe there's a different way to phrase it, but when you look at it, it's confusing, and I think as applied to those facts. The rest of the charge actually does have all of that. So if there's an argument that I don't think it's a matter of dispute. At least it shouldn't be. And the enterprise can take all kinds of forms. The charge goes on to some length about that, but I don't think that that one sentence is appropriate. And so if something comes up during the summation that makes me change my mind, we can revisit it then. Judge DONNELLY was confused as to the language that should and should not be in the jury instructions. She put it in. After Thomas FARINELLA argued it, she pulled it out. The government responded. She put it back in. If the judge was confused, of course the jury was confused. It was a perfect appealable issue. In addition to it being consistent with you saying your client is not guilty, the RICO instructions should have been challenged. To say your client is not guilty of RICO and then you don't challenge jury instructions rooted in RICO is a contradiction to your argument. You are contradicting what you're saying. On the record, she stated 3 times she is not challenging jury instructions, nor could she. She shot her own argument in the foot. He gave her 3 opportunities to amend it. She doubled down and tripled down on her contradictory statement. It's impossible for them to rule in her favor on the RICO charge because she said her client is not guilty of RICO and did not challenge RICO instructions to the jury, which is what they use to base their decision on. And he said it 3 different times to move her in that direction because it's impossible to win RICO if you don't challenge RICO instructions to the jury, which means they base their decision on correct instructions, which is how he emphasized it. It was mandatory that you challenge the jury instructions because it supported your argument. To not challenge jury instructions contradicted her own argument and made it impossible for them to rule in her favor on RICO. The New York appeal is botched. There's no way they can legally rule in her favor on RICO because she stated on the record 3 times she is not challenging jury instructions that were rooted in RICO. She said on the record she is not challenging jury instructions that were rooted in RICO, but her client is not guilty of RICO. She contradicted her own argument, which made it impossible for them to rule in her favor. The Illinois appeal is botched. She said Judge Leinweber using the word could was a stream of consciousness, a look into his psyche. This is not Miss Cleo's psychic hotline. A court of law does not work on psychic ability. It does not work on streams of consciousness. It does not work on you guessing the thought patterns of the judge. It's a court of law. We heard the Illinois appellate judge state at the end of her oral argument, no circuit agrees with her position. That means she lost Illinois. This is what an idiot looks like.
This road all the way down, you're going to take a sharp left, okay, up here, past this tree here, okay? Once you get up here, you're going to take another sharp turn. And over here, this is where you have me fucked up at. Right here in this place.
But in the game, I'm wiping the field with them to the point where they don't even compete anymore. This is the reckoning. 2024.